understand that, Dr. Watson, but you did not review the mental health records from Abundant Life prior to January 8, 2023.
That's correct.
That's correct. You did not conduct any psychological testing?
No, that wasn't necessary.
Okay. And you did not refer Ms. Warner for psychological testing, correct?
Again, not necessary. That's correct.
Did not look at any of her social media reports?
Social media?
Any social media postings or?
No social media.
Did not interview her coworkers?
It depends on, well, I didn't interview them directly. I had access to depositions.
And you did not observe her functioning in the community?
No, personally, no.
Didn't interview any of her therapists or healthcare providers?
No, not necessary.
Did not interview family or friends who were familiar with her functioning in the community?
No.
Did not review any of her education and training records at the cosmetology school that she attended after the shooting?
I don't believe I had those in the records. I don't recall that.
Did you ever seek verification of her self-report about not using recreational drugs?
That was replete in there was plenty of information about that in her medical records throughout. All of it was consistent. Everything that she said to me was consistent in medical records going way back until 2016.
Those were her self-reports.
Right, but there was no testing from any clinician, from the family practice or anything that indicated that she has ever had any substance use problems, that there was any concern, that there was any need to treatment, that there was any urine, drug, or blood tests related to it. That's just not in the records.
I understand that, but I'm asking you, did you seek verification about her self-report about whether she had used recreational drugs?
Seek verification other than the medical records?
Yes.
Do you mean, I don't know what you mean verification.
Did you review any text messages?
Whose text messages?
Ms. Warner's text messages.
Text messages about whether or not she uses drugs?
Yes.
No, I didn't.
And you told the jury about Ms. Warner having a dream about a student on the day of shooting other than the student who shot her, correct?
Yes.
Did you ever gather more details about that student to determine whether he was the student who on the day in question told her that JT had a gun?
I'm not following your question.
You talked about the student
Mm-hmm.
who she mentioned dreaming about on the day of the shooting other than JT.
Okay.
And I'm asking you, did you gather any additional details to determine whether he was the student who had told her earlier in the day that JT had a gun?
No.
And you never interviewed her boyfriend even though they lived together?
That's correct.
And he came to your office in Pennsylvania the first time when you met her in person, you didn't interview him?
No.
Did you ever review the school security video in the moments immediately after the shooting?
No.
And you never reviewed, again, any text messages or social media postings?
That's correct.
And you've not met with Ms. Warner in person since October 15, 2024?
That's correct.
And you've not reviewed any of her counseling records since June 10, 2025, is that correct?
Whatever is there in my report. So I think that was the last set before my last meeting with Ms. Zwerner.
And you addressed the tragic loss of her father, correct?
Yes.
And that was something that you said she had worked through?
Yes.
Okay, and that was, but you didn't review the Abundant Life Partners records prior to January 8, 2023, correct?
Objection asked and answered.
Any response to that?
I can try to rephrase.
All right,
So
it's sustained.
you did not see in other records where she had been treated for PTSD symptoms related to her father's tragic death?
No, I didn't see anything like
Didn't
that.
see that because you didn't review the Abundant Life records.
Objection asked and answered.
Sustained.
And you talk about Ms. Warner being reluctant to be in the public or have a public presence, correct?
That's correct.
But did you review any of her media reports or media interviews that she's giving?
No.
And that would be a public presence. Would you agree? If someone's on the
That she's
Today
appearing in public?
Show, public presence.
So I think that we might, I'm not sure what the circumstances were and what sort of measures were put in place for her to make that appearance.
Did you review the GoFundMe site created by her sister?
No.
And that putting the story out that way?
No.
That's all I have, Dr. Watson. Thank you.
Thank you.
Any redirect?
One clarifying, there was a question earlier from Ms. Douglas about meeting on Teams in July of 2024. That meeting actually took place July 2025.
That's correct. Thank you.
That's all I have, Your Honor. Thank you.
Okay. All right, may he be excused?
You may be.
All right, you are released from your subpoena. Thank you for coming and testifying
Thank
today.
you.
All right. Good time to take a short break.
I think so, Your Honor.
All right, and who's going to be your next witness?
It'll be Ms. Zwerner.
Okay. All right, we'll go ahead and take a 15-minute recess, and then we will call the next witness. All right. All right, we're being recessed till 10:50.
Thank you, Your Honor.
may be seated.
All right. Are you ready to call your next witness? All right. Bring the jury in.
Please stand for the jurors. Nine jurors in the box.
You may be seated. All right, ladies and gentlemen of the jury, we had to handle some matters. Those are taken care of, and we are now ready to proceed with the plaintiff's case. Call your next witness.
Abigail Warner, Your Honor.
Do you swear that the testimony that you're about to give is the truth, the whole truth, and nothing but the truth, so help you God?
Yes. Thank you, Your Honor. And Abby, can you tell the jury your name, please?
My name is Abigail Zwerner.
And Abby, how are you feeling right now?
I think nervous is a big one. Nervous, anxious, a lot.
And Abby, the jury has already heard a little bit about yourself from your mother and your sister. So just tell the jury, how long were you a teacher?
About 2.5 years.
And where did you teach at during that 2.5-year period?
Richneck Elementary.
Tell the jury what grades you taught.
I came into 4th grade, my first year of teaching. That was when we had the virtual hybrid year. And then the following 2 years, I taught 1st grade, all at Richneck.
And how did you enjoy teaching?
I liked it. I do remember it was stressful a lot of times. Being a new teacher, a lot of new experiences, a lot of ups and downs I remember. Yeah.
And now, Abby, I'm just going to ask you a few questions about January 6, 2023, okay?
Okay.
So tell the jury, when on that day did you first hear about JT might have a gun?
It was before recess.
And do you remember who told you that?
Amy Kovac.
And when Amy Kovac told you that, why did you not go to Dr. Parker?
I knew that she was going to tell Dr. Parker.
Did Amy tell you she was going to tell Dr. Parker?
Yes, she told me that she was going to tell Dr. Parker.
And did Amy tell you that 2 girls had advised her of the fact that JT might have a firearm?
Yes.
Do you know who the 2 girls were?
I did not.
So she didn't even tell you which kids in the class had told her that?
She did not tell me.
And no other kids told you?
No.
Okay. So you heard it from Amy, and Amy said she was going to tell Dr. Parker at that time?
Yes.
Were you told to keep an eye on JT by Amy?
Yes.
And is that why you were texting and communicating with Amy during recess?
Yes.
And Is that why you texted Amy about what you observed JT doing before recess?
Yes, because I knew that once Amy had informed me of the information that the students had told her, I knew that Amy was going to then relay the information to Dr. Parker.
And again, no one else had told you anything about a gun besides Amy.
Correct.
And, Your Honor, I would like to publish and pull back up.
Which is that?
That is the picture yesterday of Abby wearing the shirt. Oh, 90C? Is it 90C? I'm being corrected that it's Plaintiff's Exhibit 90C, Judge.
Okay. Any objection to that?
No objection to that.
Right. It's already been admitted, correct?
Yes, it's already been
All right,
admitted,
got
Your
it.
Honor.
Yep.
And Abby, do you recognize that photo? It's on the screen in front of you.
Yes.
And what year is that from? Do you know?
I have slightly orange hair. Looks like it's washed out, so it would have been the 2022-2023 school year.
Okay, so you're in your first grade classroom, room 11?
Yes.
And if we can zoom in on the orange sheets that are behind your head, do you see those?
Yes, I do.
Can you tell the jury what is that?
That would be our handbook, our school's handbook. I believe it was titled the Crisis Management Plan. I may be wrong on the title of it, but it was the Tier 1, Tier 2, Tier 3.
So that's the school, that's a handbook that you would reference?
Yes.
And why would you reference that sheet?
For the behaviors, it was like a left and right side.
And why would you look at that, the left and right side?
The like possible displayed behaviors on the left, and then on the right side, actions to take as a teacher.
And Reed, if we can only display to council, please, Exhibit 108, and it would be date stamp 9074 and 9075. Thank you. And Abby, do you see two documents in front of you?
Yes.
Do you recognize those two documents?
Yes.
And what are those two documents in front of you?
The on the left and the right side, it looks like the three. I don't know how to explain it. It's like the combined on the one sheet of paper that I had on the orange sheet of paper, like the level 1 behaviors, and then on the right side of the screen, level 2, and then level 3 behaviors. I had that all on one sheet of paper, the orange paper on the wall.
So the exhibit that we just showed to the jury, the box that you had of the 3 tiers, is from this document?
Yes.
Your Honor, at this time I would move to submit this document as Plaintiff's 108, and we would mark it as 108.
All right. Any objection?
Object, Your Honor. This witness can't authenticate. This is a handbook from Richneck Elementary. She's not an employee. She can't authenticate the document.
Well, she's identified it. That's overruled.
Thank you, Your Honor.
All right. So admitted.
Thank you.
Plaintiff's 108.
May I have permission to publish it to the jury, please?
You may.
Thank you. And Abby, we're now sharing this with the jury, so can you tell them again where this Section 3 came from?
The Richneck Elementary School handbook.
And the chart that the jury is seeing on those 2 pages, is that what was combined into one chart in the photo that we had just previously showed the jury?
Yes.
And can we publish to the jury Exhibit 90C? Is it 90C? Thank you. And if we can zoom in, that orange piece of paper behind your head is what has the chart on it with the Tier 1, Tier 2, and Tier 3 behavior.
Yes.
And then if we can zoom in on the level 3 behaviors on the second part of the screen, please read. And do you see what's on the screen at this time?
Yes. At the top it says level 3 behaviors immediately reported to the school security and or an administrator.
And in the student behaviors, is there a possession of a weapon listed?
Possession of a weapon.
And then next steps, that's for the administrator to do, correct? That was your understanding?
Next steps.
And if we, on this date, Amy Kovac went and reported it to Dr. Parker, correct?
Yes.
Thank you. And we can take that down from the screen now. Thank you, Reed. So, Abby, now tell the jury, what did you see right before you were shot that day on January 6, 2023?
The moment went by very fast. I remember Dr. Watson touched on it briefly earlier. The look on the student's face is a large memory that I have. I do remember it was like a very blank look, but it wasn't a blank look at all on his face.
And is that why you lifted your hand? Did you know what was about to happen?
Yes. Yep.
And what is the last thing you remember that day at the school?
The last thing I remember at the school. Obvious, I thought I was dying. I thought I had died. I thought I was either on my way to heaven or in heaven, but then it all got black, and so I then thought I wasn't going there. And then my next memory is I see two coworkers around me, and I process that I'm hurt, and they're putting pressure on where I'm hurt.
And Abby, can you describe for the jury a little bit about how you're still feeling physically and emotionally? And I know that's a big question.
Physically,
Can you describe how it is with your left hand still? The things you can and can't do, even to this day? So Abby, can you tell the jury when we have lunch together, are you able to open your potato chips, or do I open your potato chips for you?
I asked you, we catered sandwiches in a box, and a small bag of chips and cookies were catered, and I was trying to open the bag of chips on my own multiple times, different ways, trying to hold it different ways. And I eventually asked you to open it. It's the same thing with water bottles. Overall, I would say I do struggle with doing things.
And for example, we heard from your sister yesterday, and she described a change in your relationship with not only her but friends. Are you able to explain a little bit to the jury about how you feel maybe those relationships have been changed?
The best I can explain it, it's like I still feel connected and close, but it's also that feeling of distance, a little numbness, and it's like I know I trust the person I'm with. You know, I love them, I know them, but there's something that's just different. I can't necessarily put it into words.
And what about, we heard from your mother about the movie Hamilton. You were planning to go to it that day. What happened that changed your mind when you had already purchased the tickets and made those plans?
It was a Saturday. I remember waking up. I woke up and I remembered that there was a scene where two characters had dueled with firearms, and when we had started making the plans to see the movie, when the Saturday was coming up to see the movie, it just never flew through my mind. I had seen Hamilton before, but for some reason when I woke up that day to go see the movie, it just flew right into my head, and just an overwhelming sense of, I felt like everything just came over my body. And I remember I called my mom. I don't remember if I was crying on the phone to her. I don't remember if it was afterwards, but I remember crying a lot. And I remember that afterwards they were asking me what else would I want to do instead that day. So, okay, we can't go to the movies, what do you want to do instead? Where else would you want to go instead? And I remember telling them nowhere, like I can't go anywhere, I just want to stay home. I'm not going anywhere today, I can't. And I remember that it was my mom and my sister, so it wasn't just my mom and I planning to go, it was my mom, my sister and I, all three of us planning to go. And then they proposed to come over to my place, and even that still, I didn't want, no, just leave me alone. I don't want to go anywhere, I don't want to see anyone, I don't want to, no, to my mom and my sister.
Well, Abby, I know this has been difficult for you, so that's all the questions I have. I appreciate it, okay? Thank you. But stay there. There may be other questions.
Thank you. All right, cross-examination.
This may take a little bit of time. I don't know if you want to go try to get through before lunch.
I'm sorry?
My course might take a little bit of time. Let's get it started.
Yep.
Ms. Werner, I have a few questions so that we can make sure the jury understands the whole picture. You've been working as a teacher for a few years at the time of the incident, is that correct?
Yes.
And you had a number of children in your class with some academic issues?
Yes.
You had some children in your class with behavioral issues, is that correct?
I faintly remember.
And when you were dealing with student misbehavior, you would start by talking with the student, is that correct?
Most likely, yes.
And if you needed help, you would ask for guidance or coworkers or administrators to help, is that correct?
Yes.
You would go to Dr. Parker at times, correct?
At times.
You would email her, true?
Yes.
You'd walk in her office.
Yes.
And if necessary, we'd get the guidance counselor to take the student to Dr. Parker's office.
At times.
And Ms. West was another first grade teacher. She was across the hall from you, correct?
She was.
Lead first grade teacher. Sometimes go over there if you needed to speak with her.
Mhm.
You had a phone in your room,
Yes.
and you could call a parent on the phone in your room,
I don't think I've called a parent during the day.
but you could if you needed to.
Yes. Yes, I had a classroom phone.
And you could call the office.
Yes.
Mr. Coleman, can you please show to the witness and counsel Exhibit 90A? Yes, sorry, Defense 90A.
That is plaintiff's 90A, is that correct?
Yes.
All right.
No. She said defense 98 to me and then plaintiff to you, so I just want the record to be clear.
Oh, Defense 90A.
All right. Is that in evidence?
Not yet.
Okay.
Ms. Warner, I'll give you a minute to look at this document.
Are these from me or someone's messages to me?
Is your phone number 804-424 or 80?
So they're from me.
That's a text from you.
Okay. Yes.
Have you had a chance to look at the?
Yes, I
the
read
page?
them.
Is that a text you sent on October 15, 2021?
If that's what it's stated, yes.
And you sent it to Rosalie List.
Yes.
And Ms. List taught with you at Richneck, correct?
Yes.
Was she another first grade teacher?
Yes.
Your Honor, I'd move to admit Defense Exhibit 90A and publish to the jury.
Any objection?
Your Honor, I would just object. I don't see how it's relevant. This is from October 2021. It's not regarding JT or the year that this happened or the date of the offense.
Yeah, how is this relevant?
It's relevant. If the court will let me explore with her, we can sidebar and I can tell you, but I don't want to obviously do that before I question her about it.
I need you to state why you believe it's relevant.
The text is a text about evacuating the classroom when she felt that she was in danger, that she had done that before.
That's quite what it says, but you can read it, Your Honor.
I think the bottom one is relevant to that, but the top one isn't. So, I mean, I'll overrule the objection as to the bottom one if we redact the phone numbers and then redact the top text.
In Your Honor, pending whatever ruling we make, can we ensure that this remains published only to the witness because it does have private phone numbers that I don't think need to be
Correct. So if we could just post that as it's highlighted there, I'm okay with that.
Yeah, I was not aware of any court ruling about redacting text messages
Well, phone numbers.
or phone
Yeah,
numbers?
phone numbers from
Okay.
the text need to be, yeah.
We can redact it before it's submitted.
Okay.
Am I allowed to publish it to the jury before?
Yes. It goes up exactly like that. Okay.
Ms. Werner, do you recall an incident the year prior with a student named Q?
I don't.
Do you recall you had a student in your class named Q who you felt in danger of and you had to evacuate your classroom?
I don't. I remember a student with the name Q, but I don't remember any of this.
So if you've looked at a text message where you talk about evacuating the classroom because of student Q and feeling in danger the year prior, you would disagree with that?
Yes, but I also know I've never have officially, technically done an evacuation procedure. I don't know what that... I've never performed a school classroom evacuation.
So Ms. Werner, if you see on the text,
Mm-hmm.
had to evacuate my room early for lunch,
Yes.
and that was because of Q, wasn't it?
Yes, I read that.
And you recall, does that refresh your recollection?
I don't recall what happened.
Mr. Coleman, can you publish to the witness and counsel Defense Exhibit 91D? Have you had a chance to review?
Mm-hmm.
Is that also a text message from your phone that you sent?
Yes.
And you sent it on December 15, 2022 at 5:22 p.m.?
Mm-hmm.
And that
Yes.
was a few weeks before the events that bring us here today. Is that correct?
Yes.
And you sent it to Jen West, Anissa Miller, and Kristen Ayers, correct?
Yes.
And they were other first grade teachers.
Yes, they were.
And in this text, you told them that you were sorry for crying.
Your Honor, I'm objecting at this point. There was pretrial rulings about prior acts pursuant to Rule 404, Your Honor. This isn't relevant as well. If you can look at the text that's on the screen before Your Honor, we would be objecting.
All right,
All
so
those
there are
bases.
two separate texts, so let's just start with the top one. All right, how is that relevant?
It's relevant to credibility of the witness in terms of statements about, the jury's heard evidence that Dr. Parker didn't look at her, so this is probative of that evidence that's in court from this plaintiff's own mouth.
From December 15th of 2022?
A couple weeks before the shooting.
No, I'm going to sustain that objection. All right, and then you have a separate argument on the bottom one? Or is it, I'm sorry, let's start with the objection first. Is that to relevance as well? Or have you even gotten to that second one?
I had not gotten
Okay.
to the section.
Okay, so on the top one, I'm going to sustain the objection. All right, are you going to go to the bottom one, or did you just want the top one?
I want the bottom one.
Okay, all right, let me see that. Same objection,
Yes, Your Honor.
and is it the same date? I couldn't see the date.
It's the same date, Your Honor.
All right, thank you.
Again, it's about a completely separate incident.
Your Honor, the jury's heard testimony from Ms. Kovac and others about Dr. Parker not looking at her on January 6th, and Ms. Kovac made comments about Dr. Parker not doing certain things. This is a text message from Ms. Werner discussing feedback from Dr.
I
Parker.
object to all of the text message.
It's directly relevant.
To what?
Credibility of the witness. It's probative of actions taken on the day of, which they've been able to place in evidence.
No, I'm gonna sustain the objection. It's not relevant. This is on December the 15th.
Thank you, Your Honor.
All right.
Ms. Werner, there was an incident with your cell phone on January 4, 2023, correct?
Yes.
And it involved the student JT, correct?
Yes.
And he threw your phone in the classroom?
He slammed my phone to the ground.
And it broke the screen protector?
Yes.
When he did that, you took him by the hand, correct?
Yes.
And you removed him from the classroom?
Yes, I brought him to Miss West's classroom across the hall.
And you asked her to call guidance, correct?
Call for, yes.
And Mr. Rawls came?
I asked her to call for help on her walkie-talkie, and Mr. Rawls and Miss Palladini came.
Okay, so Ms. West could call for help on the walkie-talkie?
Yes, she had a walkie-talkie. I did not.
Okay. And Mr. Rawls came?
Yes.
And he removed JT from the classroom?
Yes.
And he was suspended for 1 day for that, correct?
Yes.
And he returned to school on January 6th?
Yes.
His mother brought him into class?
Yes.
And she apologized for what JT did?
Yes, he did as well.
He did as well?
Yes.
And he offered to pay for the screen protector?
Yes. Casual conversation.
You did not notice anything off about JT when he first arrived at school on January 6th?
I did not.
Now, your class went to lunch around 11:15 to 11:45, is that correct?
Yes.
And we've heard about an incident with JT in the lunchroom, and you personally went to Dr. Parker about this incident, correct?
Yes.
And to be clear, when you went to Dr. Parker about this incident, you did not report to her anything about JT having a weapon?
No.
So you went back to your classroom after you left Dr. Parker's office?
From my memory of that day, yes, but throughout this week I have learned some things.
Do you recall going back to your classroom at some point before recess?
Yes.
And Ms. Kovac was in your classroom?
Yes.
And you learned from Ms. Kovac that 2 of your students said JT had a gun in his backpack?
I don't remember if Ms. Kovac told me who. She did not tell me which students. But yes, Ms. Kovac did tell me that students told her that the student brought a gun with him to school.
Did you ask Ms. Kovac who the 2 students were who had reported this?
I don't remember if I did or not.
Did you take measures to speak with the 2 students who had reported this?
No, I knew that Ms. Kovac spoke to them.
And they were students in your class?
Yes.
And you didn't feel the need to speak to them yourself?
I knew Ms. Kovac had spoken to them, and I trusted Mrs. Kovac.
But you don't know what Ms. Kovac said to those students, do you? Or if she said anything to the students?
I trusted Ms. Kovac. She has 20, 30 years of teaching experience over my 2.5 years.
So Ms. Kovac stayed in your room for a while, didn't she?
Yes.
About 30 minutes.
Yes.
And she spoke to JT about what the student said, right?
I don't recall specifically.
You were in the classroom when this happened.
I was.
And Ms. Kovac was loudly talking to JT.
I could not hear what she was saying.
Did you, knowing that you'd gotten this information that your student might have a gun, did you go speak with him?
I did not. Ms. Kovac was with him.
Did you, Ms. Kovac was in your classroom? So you had coverage in your classroom? Because Ms. Kovac was in there and she had 20 to 30 years of experience, right?
Was that a question?
It was a question.
Could you repeat that,
Ms.
please?
Kovac was in your room when you found out that JT might have a weapon. You had coverage in your classroom. Did you go back to Dr. Parker and say, oh, there's been a change. Now there's a report that he might have a weapon?
At that time, no. Ms. Kovac was in my room investigating the situation. She was observing the student, sitting next to the student, and at that time, I'm trusting Ms. Kovac.
Did you remove JT from your classroom as you had done 2 days prior when you took him by the hand and took him out?
No.
Did you remove his backpack from the classroom?
No.
Did you search his backpack?
No.
Did you go back to the security officer in the lunchroom
No.
who had left a little bit after this time? Is that right, about 12 o'clock?
I don't know.
Instead, you proceeded to teach a lesson before recess. Is that right? And Ms. Kovac team taught that lesson with you.
I don't remember.
So Ms. Kovac has stated that she taught a lesson on Pocahontas with you. You don't remember that?
No.
And eventually Ms. Kovac left the room, correct?
Yes.
And did you say, don't leave, please stay?
She left to tell Dr. Parker that there was a potential of a gun on the student.
But you don't know what she said to Dr. Parker, do you, Ms. Warner?
I knew that she left to tell Dr. Parker what the students had told her.
But you don't know what Ms. Kovac told Dr. Parker?
Her specific words, no ma'am, I was not there with
You were
her.
not party to that conversation.
Correct, I was not.
And when she left, did you ask her to stay or to remove him from the room or to remove his backpack from the room?
No.
Now, we've heard that you saw JT go to his backpack at some time before recess. And did you go personally convey this information to Dr. Parker?
I texted Ms. Kovac.
My question is different. Did you seek measures? Did you yourself convey this information to Dr. Parker?
No.
So you took your class to the playground, correct?
Yes.
And you were out on the playground with 2 other first grade classes and teachers,
Yes.
Jen West and Kristen Ayers.
Yes.
Ms. West, she's the one with the walkie, right?
Yes.
When you got out there, did you tell Ms. West, get on the walkie, we've got a student who might have a weapon?
I don't remember.
You don't remember?
No ma'am.
So you shared with Ms. West and Ms. Ayers what you had learned about JT, correct?
Yes.
And you observed him on the playground.
Yes.
And Ms. Kovac came out on the playground at some point, correct?
I don't remember that. I
Don't remember? And you had left the playground before while the other teachers were out there. We talked about that in your deposition. So did you leave the playground to go back in the building to personally provide information to Dr. Parker?
No.
Did you question JT about anything that you had heard?
No.
And at some point, Ms. West left the playground.
Yes, right before we went inside.
And why did she leave the playground?
To my understanding, something with one of her students.
And did she ask you to shepherd her class and your class into the building?
Yes.
And how many students would that be?
Around 40, maybe.
Because Ms. West needed to go deal with another student discipline issue.
Yes.
Did you say to Ms. West, hey, I can't take your class in. I've got my own problems here. I've got an issue with a student who might have a weapon.
No, because at that time I knew that Amy had told administration, Dr. Parker, I honestly didn't think twice. It was my understanding that administration wouldn't think twice as well
Ms. Warner.
when alerted about a potential gun in school.
But you could have taken measures yourself at that time, correct?
Yes.
And you don't know what Amy Kovac said to Dr. Parker, do you?
Exact words, I don't.
So you shepherded 40-some students in the building.
Yes.
JT was in the midst of those students, correct?
Yes.
You had the children line up on the wall out of your classrooms?
Yes.
And you went into the class
Yes.
and you did small reading group.
Yes.
You still hadn't removed JT from the classroom,
No.
and you recall that his backpack was next to his chair.
Yes.
Ms. Warner, at some point on January 6th, did a student named R tell you that JT had a gun?
No.
Do you don't recall saying, save it for later, or sit down to that student?
No.
That didn't happen?
No.
And the first time you saw JT with a gun, he was at his desk, is that correct? The
Yes.
first time you saw a gun that day.
Yes.
And when you saw that, you were shocked,
Yes.
because you didn't expect to see that, did you?
It was a real gun. Yes.
Is there a point where you didn't think he might have a real gun?
Well, the whole day I was contemplating it could be real, but it also could not. When you hear the word, he told students he brought a gun with him to school. There is that possibility.
Ms. Warner, you were asked about the staff handbook. Can you pull up, it's, what exhibit is this? Is it
108.
108? 108? Ms. Warner, 9074. Mr. Coleman, the top paragraph. Mrs. Warner, do you see the third paragraph? Can we publish to the jury? I think it's in evidence.
This is just the cover. That's all we can see.
Yeah, it's 108. Appears to be page 7, I think.
I can see it, yes.
Your Honor, may we publish it to the jury since it's already in evidence?
But this is your version, right? Your copy of it, or
No,
it is the plaintiff's?
It's
Okay,
the
very well.
plaintiff's, Your Honor.
Yes.
Ms. Warner, looking at the third paragraph, it says discipline is the initial responsibility of the teacher. Is that correct?
Yes.
You agree with that?
It says that.
And let's look at the next page. The boxed behaviors. You spoke about that with the jury a while ago. And Ms. Warner, student behaviors on the left is possession of a weapon. Do you see that?
Yes.
And the next steps are secure students and ensure safety. Did you do that when you got a report that JT might have a weapon?
I did not.
And the next step is 2, immediate notice to administrator. Did you yourself notify an administrator?
Amy Kovac did.
I'm
I
asking.
did not myself.
Did not yourself. Ms. Warner, the jury's heard a fair amount about your physical damages from your treating doctors the last couple of days. You eventually resigned from the Newport News Public Schools, is that correct? And you worked for a few months at a gym, Burn Boot Camp, is that correct?
Mm-hmm.
And you and your sister Hannah also worked out there pretty frequently, is that right?
Beforehand, yes.
Before
January 6th.
you would disagree you were still working out at Burn Boot Camp after?
Oh, I did go work out afterwards when I had started working there at the front desk in the fall of 2023. My doctor had cleared me to do light work, light exercises. So I tried my best to work out the best that I could with the weights, best I could.
And the jury has heard testimony about your emotional damages, correct? We heard from Dr. Watson today.
Yes.
You started seeing your therapist at Abundant Life regarding emotional problems back in March 2021. Is that correct?
That sounds right.
And that was about a year and a half prior to January 6th.
Yes.
And you've been taking an antidepressant daily since 2021.
Yes.
And you told your therapist that you've been diagnosed with depression and anxiety for a number of years. Is that correct?
Yes.
You've been treated for generalized anxiety disorder
Yes.
and a major depressive disorder.
Yes.
And Ms. Warner, you felt a lot of stress and burnout from being a teacher. Is that right?
Yes.
And you had also tragically lost your father in June of 2020.
Yes.
And you had worked with Ms. Gonsalves on recovering from PTSD symptoms related to that event, because that's an event you witnessed. Is that correct?
Yes.
Mr. Coleman, can you show the witness only defense exhibit 109 at 83?
Objection about this text.
Let me read it, okay?
Period. Yes,
All right,
sir.
I know you all have.
I've read it.
Hold on 1 second. All right, objection is, state your objection for the record, please.
Your Honor, her introduction of this text message is irrelevant.
Relevance is the objection. Your response?
Clearly it's relevant, Your Honor. She said multiple witnesses parade in here and say that she has social anxiety and cannot even leave her home. This was produced by Ms. Werner. It's actually an Instagram post, and it's directly relevant to her ability to function in the community following this incident, which she's placed at issue here.
All right, I'm going to overrule the objection. We can also issue a limiting instruction if necessary that it only goes towards the testimony to contradict the symptoms.
Yes, Your Honor, thank you.
All right.
Ms. Werner, is this an Instagram post you made on September 13, 2023?
It's a private message I sent to Taylor Swift.
Move to admit it into evidence and publish to the jury.
Over plaintiff's objections noted.
Would you like me to read it out loud?
No, is it posted on that? I can't see that.
It's posted.
Oh, okay.
They'll read it.
We'll let the jury, have you had a chance to read it, Ms. Warner?
Yes.
Ms. Warner, you just told the jury this is a Instagram post,
It's a private message to
private
Taylor
message.
Swift.
Private message to Taylor Swift, and you gave that message on, or sent that message on September 13, 2023. And you let Ms. Swift know that you were the teacher from Richneck Elementary School who had been shot,
Yes.
and that you had been to the Eras Tour in Philadelphia. And that was in May 2023, correct? That you went to the Eras Tour concert in Philadelphia?
That seems around that time. Yes.
That was a few months after the tragic shooting, correct?
Around summertime of 2023, I remember.
It was
Yes.
a few months after you recovered from your physical injuries. Is that correct?
4 months.
And you told Ms. Swift that you were involved in a long court case from the shooting and asked her not to post the message.
Yes.
And you state that you're trying to keep your personal life out of the media. Is that correct?
Yes.
Mr. Coleman, can you please show the witness only defense exhibit 109 at 82?
Or just have the same number, or?
Yes, it's 109 at 82, and that was 83. So it's a page number. It was produced in discovery by the plaintiff, a series of social media posts and text messages.
Right, so now we're gonna label, so I've admitted that, so that's defendants 109-82, and this is gonna be 109-83.
10983
All right,
is
for
the
identification
Taylor
at
Swift
this
count.
point.
Yes, and
Okay.
10982 is a different.
Your Honor, I think the record's a little confused.
Okay, yeah, let's try that.
83 was the one that we just looked at.
Okay.
82 is what I believe she's.
That's what I just said.
One of us had it switch. Okay. All right, so this, we're gonna, defendant 10982 is what
Correct.
you're showing her now?
Yes.
Okay, thank you very much.
Ms. Werner, I'll give you a minute to read through this document. Is this a private message you sent to the band Odessa?
Yes.
And you sent this message on September 13, 2023 as well.
Yes.
Move to admit exhibit 109 at 82 into evidence and publish to the jury.
All right, any objection?
I'm not gonna object, Your Honor.
What's that?
I'm not gonna object.
No
Your Honor.
objection. All right.
And Ms. Werner, in this message, you let, Odessa's a band, correct?
2 producers. Yes.
And you let 2 producers, it's a music show. Is that
Yes.
correct? And you let this band or producers know that you were the teacher from Richneck Elementary School, is that correct?
Yes.
And that you had been to their show in Bristow, Virginia, the night prior.
Yes.
And they're an EDM band, correct?
Yes.
And EDM is an immersive sensory experience where they use strobe lights and visuals during a concert, is that correct?
Yes.
And you told Odessa that you had had so much fun at their show that you were in awe and hoped to go back again.
Yes.
And then you also told Odessa that you were involved in a long court case from the shooting and asked the band not to repost the message
Yes.
because you were trying to keep your personal life out of the media.
Yes.
Ms. Werner, you've given interviews about the events at Richneck on numerous occasions, correct?
Yes.
You've been on the Today Show.
Yes.
Your sister's also created a GoFundMe page.
Yes.
There are t-shirt sales that benefit you. Now, Ms. Werner, you went to cosmetology school, correct? And that was in January 2024, is that right?
Yes.
And this was something that you had considered for years prior to the events of January 6th, is that correct?
Not realistically.
Mr. Coleman, can you please show the defense exhibit 96B to counsel and to Ms. Werner?
I can't see the date on that. We'll bring that up.
Your Honor, I think the context would be helpful with counsel as well, so that we can understand the broader scope of that.
All right. Are you gonna lay some foundation?
Yes.
All
Ms.
right.
Werner, is this a text you sent to Rosalie List? And Rosalie List was a fellow teacher with you, correct? And
Yes.
that was on September 11, 2021.
Yes.
And in the text you said, "Ugh, I'm not ready to teach. If I quit, I'd go to cosmetology school." Is that right?
Yes.
That was a couple years before the events that we're here for today.
Yes.
Ms. Werner, Mr. Coleman, can you please pull up Exhibit 96? P1.
96B, Ms. Douglas?
I think it's just 96, Your Honor. Plain 96.
Display 96. Do you want to display this one?
The text message about cosmetology school
Yeah,
has not yet been.
Oh, I'm
released.
sorry. I thought
It's
it had been,
identified
yeah.
as 96.
We'll go ahead and pull 96B up. I apologize. I thought it was up. So that was a text that you sent to Miss List a few years before.
Yeah, I think I also joked about stripping as well.
Ms. Werner, I didn't include that text. I didn't include that text. Apologies for getting the numbers wrong, but Mr. Coleman, can you please pull up Exhibit 96?
Are we admitting 96B?
Yes, admitting it.
Okay.
I have no objection, Your Honor.
All right.
Have you had a chance to look at the text?
Yes.
Is this also a text you sent to Miss List on October 17, 2021?
Yes.
May I move to admit Defense Exhibit 96 and publish to the jury?
Let me see what he's able to bring up there. All right, so that's what you're at. I guess you can't see?
I can't see, no.
Okay, why don't you take a look at that and make sure that's what you want to
Yeah.
publish? All right, any objection to those three parts of that exhibit?
Just want to make sure, Your Honor, when we're getting these snippets up on our screen that are being shown to the jury, that's not the full document that's been disclosed. So as long as whatever Your Honor's ruling on is just what we're seeing on the screen.
Correct.
Okay.
At this time, and then if you
Correct.
need any follow-up or whatever else you want to, I'll let you redirect.
Understood, just wanted to make sure.
Okay, so we can publish this
Yeah.
as shown on my screen.
That's fine.
All right.
Have you had a chance to look at it?
Yes.
And did you find an Aveda school for cosmetology and send it to Miss List?
Yes.
And told her that they had a school in Arlington?
Hmm.
Mr. Coleman, can you please show the witness Exhibit 96J? Ms. Warner, is this a text you sent to Miss List on October 18, 2022?
I'm not sure who I sent it to, but yeah, it's a text I sent.
Okay. It says to Rosalie List. Is that correct?
I can't tell from here.
Can you see?
Cover that. You can show it.
Yes, I did.
All right, so remove
And
that.
that's about a year later, correct? the fall before the events that bring us here today.
Yes.
Any objection?
Move to admit it.
Okay. All right. As shown on my screen.
And Ms. Warner, in the text, you told Ms. List that you didn't even know if you wanted to teach anymore, but you didn't want to waste all the money that you had spent going to school. Is that correct?
Yes, I said that.
And you said that you would love to go to cosmetology school.
Yeah.
You went to cosmetology school, correct? About a year after the events that bring us here today.
Yes.
Mr. Coleman, can you please show the witness only and counsel Defense Exhibit 127? Page 3. Ms. Warner, are these your records from Empire Beauty School?
Yes.
Your Honor, may I move to admit and publish to the jury?
Are you just doing one page or both pages?
I think it's going to be several pages of that document.
Okay, so it's one document.
Yes, sir.
All right. Any objection to the entire document?
Your Honor, it has her address on it.
Okay.
We can redact that before
Yeah,
it's
we can
submitted to the court.
redact the email, address, and phone number, please.
Ms. Warner, I want to focus your attention to page 4. In the personal background section. Can we publish to the jury, Your Honor?
Right. That mirror.
Your Honor, again, I don't understand the relevancy of all of this, but I don't think it hurts her either.
All right. Your responses to relevance.
Ms. Warner has told the jury that she can't use her hand, and she's become a cosmetologist. Clearly, this is relevant.
Okay. I'll allow it. Overruled.
Ms. Warner, I'm looking at the personal background section. Question 4. Ms. Warner, in that question you were asked, is there anything that might prevent you from achieving your dream of starting or completing school, meaning cosmetology school, correct?
Yes.
And your response was part-time job at gym.
Yes.
Mr. Coleman, can we move to pages 20 to 22 of the same records? Focus on page 21, and that is physical requirements of the industry. May May we publish the heading physical requirement of the industry to the jury?
Any specific objection to that, besides your continuing to relevance?
Judge, I would object to this based on hearsay in the document.
All right, you have a response to that?
It's not offered for the truth of the matter. She certified that she had no issues with these.
And
and that these are
she's
fine.
identified the document itself, so I think she's familiar with it. I'm going to overrule the objection.
Ms. Werner,
If you read, I guess you need to, I will say, you need to lay a little bit more foundation as to this page. She wrote the other pages. This is not her writing, so.
we can jump ahead and then come back. Let's go to page 22, and I think that will take care of the issue.
All right.
Mr. Coleman, can you go to page 22? Ms. Werner, do you see page 22 with your signature on it? Is that your signature?
Yes.
Can we publish that to the jury?
All right, I'll overrule it. That is her signature, and she signed that she understood the agreement. All right.
Go ahead and pull up the signature. Okay. Jury's looking at it now. Ms. Werner, that's your signature on this document, correct?
Yes.
And if you go back to the prior page, it discusses the physical requirements of the industry. On page 21, we'll go back to that.
Yes.
When you signed the document, you acknowledged the physical requirements of the industry of cosmetology. Is that correct?
Yes.
And let's go through them. The first one is arm-hand steadiness, the ability to keep your hand and arm steady while moving your arm or while holding your arm and hand in one position. You not acknowledge that you were able to do that, correct?
Yes, I signed the document.
Second one is manual dexterity, the ability to quickly move your hand together with your arm or your hand to grasp, manipulate, or assemble objects. You signed that as well, correct?
Yes.
Finger dexterity, the ability to make precisely coordinated movements of the fingers of one or both hands to grasp, manipulate, or assemble very small objects. You acknowledge that as well.
Yes.
Trunk strength, the ability to use your abdominal and lower back muscles to support part of the body repeatedly or consciously over time without giving out or fatiguing. You acknowledge that requirement, correct?
Yes.
Multi-limb coordination, the ability to coordinate two or more limbs, for example, 2 arms, 2 legs, or 1 leg and 1 arm, while sitting, standing, or lying down. It does not involve performing the activities while the whole body is in motion. You acknowledge that requirement, correct?
Yes.
You completed the Empire School cosmetology program, correct?
Yes.
And to become licensed, you successfully completed the 1,500-hour education requirement.
Yes.
And you passed all practical examinations prior to earning your license in July 2025. Is that right?
Yes.
And to do this, you had to complete subject matter instruction at the school?
Yes.
And you also had to complete practical performance examinations.
Yes.
This involved hairstyling, hair cutting, and hair coloring.
Yes.
And in fact, you were quite good at school, weren't you, Ms. Warner?
Was I good at school?
You had a 97.4 GPA.
On my tests, yes.
And you have provided photographs of your work as a cosmetologist to salons. Is that correct?
Yes.
Mr. Coleman, can you please pull up Defense Exhibit 112, page 6? Do you recognize this document, Ms. Werner? Move to admit and publish to the jury.
Any objection?
No objection, Your Honor.
All right.
I think there's several pages if you want to take your time going through them.
I see these three.
Mr. Coleman can move to the next pages so that you can look at them all and the jury can see them. It's page 7.
No faces in any of them, correct?
I don't believe
No
so.
faces, Your Honor.
Okay.
Are they, Your Honor, they have different stamps.
I was just gonna get to that, yeah. Pages 6, 7, we're now at 8.
Yeah, and we
All right.
we don't have an objection to them, but for the record's purpose, we were shown 6, and now we're looking at 7 and 8, and I just
Correct.
want to make sure it's clear.
Yeah.
It's all exhibit 112, pages 6, 7, and 8.
That's how they'll be referred to. I guess we don't need to black out those faces, right?
Ms. Werner, have you had a chance to review all of these? And is this a composite of your abilities and work as a cosmetologist? Is that right? And no doctor's ever told you that you cannot work as a cosmetologist?
Correct. I will say, flipping through the photos, can we go back to the first one, please?
Sure. Page 6.
Yes. All of these three right here, I did have assistance pretty much throughout with an educator or at least one classmate.
Understood. But you've put these photographs out to salons in order
One
to
salon.
get one
Yes.
salon in order to get a job.
Yes, one job that I applied for.
Ms. Werner, we heard Dr. Watson testify that the use of recreational substances would change his findings. Do you recall that?
Objection, Your Honor, misstates the testimony.
Can you re-ask ask the question again for me?
Ms. Werner, you heard Dr. Watson discuss whether you had reported a history of using substances. Is that correct?
Objection, that was also not part of the testimony, Your Honor.
Yeah, I don't recall that either, so I'm gonna sustain it on misrepresenting the testimony unless you can prove otherwise.
Ms. Werner, you heard Dr. Watson say that part of his evaluation was to determine whether someone had any experience in their life before what we call the incident event. Is that right?
Could you say that one more time?
Do you recall Dr. Watson, you were sitting here for his testimony, say, when considering someone's history, part of his evaluation was to try and determine whether somebody has had any experience in their life before what we call the incident event. Do you recall that?
Yes.
And do you recall him saying that whether or not that individual has other factors that may be influencing their behavior and their symptoms, for example, is that person using substances? And you reported to Dr. Watson
Your
that...
Honor, it's an incomplete statement of the transcript. It talked about addictive use of substances.
What are you reading from?
The transcript of Dr. Watson.
Okay, I just wanted, obviously I can't see what you're looking at. Did you read it exactly as it's
Yes,
stated?
for example, is that person using substances an addiction? Are those addictions actually more likely to be responsible for the symptoms?
Right, so your question is, did you hear him say that? Overruled any of that? Withdraw the objection at that
Now
point.
that it's been read in full, yes,
All
Your
right,
Honor.
very good.
And Ms. Werner, when you reported to Dr. Watson whether you were using substances prior to the event, you didn't report truthfully to that, did you?
No.
I don't have any further questions, Your Honor.
All right, how long do you plan for redirect?
Short, 10 minutes, Your Honor, 15 minutes. Hopefully that's not in time.
Right.
So Abby, just a couple more questions. I know you've been sitting there for a little bit. First, tell the jurors, are you proud of your work as a cosmetologist thus far, getting that certification?
I am.
How hard was that for you to do?
Really hard. I had a lot of pain. I had a lot of help. But I did it. I did it.
And is that something that's brought you joy in the past, hair and makeup? You've seen your previous text messages. Is that something you enjoyed as a hobby prior to
Yes.
teaching?
Hair, makeup, yes.
Did you ever think you were really going to give up teaching to be a cosmetologist?
No, that's figure of speech. I joked about stripping.
Were you really going to do that?
No.
And tell the jurors, you're not able to get a job right now as a cosmetologist because of your hand, correct?
Yes, my previous surgery this April, it's still healing. I was wearing a brace until earlier this month, and was just recently being able to take it off earlier this month. So it's still a little bit more, I guess, raw, if you will, still getting warmed up to move again.
And when you were getting certified, did everything take you much longer than everybody else to do the hair? Without help, if you didn't have the help.
I wasn't fast at hair. I remember that. I remember I felt like I took a very slow time completing tasks, completing people's hair.
And after you've done that, how is your right hand, the hand that was not shot?
The past multiple months, I've noticed pain in this area, overuse, and now my wrist as well.
And is that from overuse of your right hand?
That's what I have been told.
And tell the jury, when you got that part-time job at the gym, why did you get that job?
I remember, when I think about that, it just makes me remember I just wanted to feel like a person again. It was a familiar place, the gym my sister and I were a part of. We went to almost every day, not all the time.
Before the shooting?
Yes, before January 6th. So very comfortable with the place, very comfortable with the people there, the workers there. And it came to my attention that they needed an extra person at the front desk just for a little bit of time, early in the mornings.
At that time, were you having a hard time getting out of bed?
Yes, but it was something like I just felt like I needed to be pushed to do that. I had to start feeling like a person again. Try to.
Thank you, Abby. That's all the questions I have.
All right.
Just one follow-up.
Ms. Warner, you talked about being able to go to burn boot camp before January 6th, but not after. Mr. Coleman, can you please show...
Your Honor, that wasn't the testimony.
Well,
I'm going to ask you to rephrase that.
Ms. Warner, you were going to burn boot camp 4 times a week in August 2023. Is that correct?
to work or to work out?
To work out.
I don't know off the top of my head how often it was.
Mr. Coleman, can you please pull up Exhibit 122 P1 so that the witness can familiarize herself with the record? Just publish it to her and counsel.
Which part am I looking at?
Looking at the record to see if you can identify this record.
Yes, it's from my family practitioner.
Okay. And what is the date of the record?
August 2023.
Mr. Coleman, can you go page 2 of the record, under the heading Depression.
And Your Honor, I am gonna object to this document coming in based on hearsay or authentication.
Yeah,
if
she
tries
hasn't
to
moved
do
it
that.
in yet, right.
But certainly
I think she's
refresh
just,
her memory.
at this point, you're just asking her whether or not she did or did not say this, correct?
Yes, Your
All
Honor,
right.
I have no intention of moving this into evidence.
Very well.
Just want to ask Ms. Warner about it. Ms. Warner, do you see the heading Depression?
Yes.
And it says 8/5, is that August 5?
Yes.
Went back to gym with sister 4 times a week mostly.
4 times a week, mostly. Yes.
Mostly, by August.
At most 4 times a week.
No further questions?
All right, you can step down and sit back at council table. All right, I think now's a good time to take a lunch break, and then I'll hear motions. I'll give you a chance to talk, and at that point, over lunch, I would appreciate you making sure there are no other witnesses or any motions that you want to make at that time.
Yes, Your Honor.
That's what we'll start off with, and then I'll hear any motions that are appropriate at that time as well.
Yes, Your Honor.
All right, and then we will see where that goes. Okay. All right, ladies and gentlemen, it is lunchtime. We will take our hour lunch, and you are excused. Please do not talk about this case or anything you've said or heard yet. All right, you may be seated. I believe you want to go on the record, Mr. Bright?
Going right, doesn't matter. I just mentioned to council the fact that we're going to be resting in an hour, maybe short for them, and we'll be sitting back there. If you wanted to give them more time, it may be the best time to give them a longer lunch instead of getting stuck in. The sun finally came out after.
All right, well, we'll check on them at my plan. No, I'm not going to take you up on that. 1:45. I want to get. 12. I'm sorry. 1:45. I want to get going again.
Yes,
Okay?
Your Honor.
All right. Court is in recess to 1:45.
You may be seated.
All right, good afternoon. All right, kind of want to go over, I guess, the plan for the afternoon. It's still your intention to rest?
Yes, Your Honor. We have just the exhibits ready to be tendered to the clerk that have been already moved and admitted by Your Honor during the pendency of our case. They've all got the stamps and stuff on them now.
Your motions?
Yes, Your Honor. In the event that there was an adverse ruling, I would intend to call Deputy Blythe as the sole defense witness for today, and then I would ask for additional time after that to confer with counsel about any additional witnesses that we may call, depending on how that shakes out and how this motion proceeds.
Okay. All right. So what I've done before is I've let the plaintiff rest outside the presence of the jury. We've done the motion so the jury's not up and down, and then I will let you officially rest in front of the jury, and then I'll ask you to call your first witness. Does that make sense to everybody?
Yes, Your Honor.
Okay. All right. You have yes, Mr.
There's a
Burke.
motion about the first witness before we get to that witness.
All right, but after you rest.
Yes, yeah.
Okay. Right. Okay.
Schedule-wise.
All right. Very well. All right. You have exhibits you'd like to tender?
Yes, Your Honor, I have, and I'll just go through them in Ms. Douglas's presence. We have 3A, 3C, 3E, 3F. Those were all during the testimony of Corporal Blythe. Then we have 90A, 90B, which were admitted during the testimony of Miss Julie Zwerner. And we have 90C, which was admitted during the testimony of Hannah Zwerner. And we have 108, which was admitted, the sections of 108 that were admitted during the testimony of Abigail Warner. And then on a flash drive, Your Honor, we have Exhibit 4, 110A, 110B, 9A, and 90D.
Okay. Madam Clerk, does that match up? All right, very well.
And
Any
20
objection besides everything already noted?
No
Okay.
objections preserved on as argued.
Correct.
And 22 was previously admitted and provided to the clerk.
Okay. All right, with admission to those objections preserved, do you have a motion?
Yes, Your Honor, we rest now.
All right.
We do wish, and it's to Your Honor's preference, we wish to raise that motion for reconsideration on Your Honor's ruling as it relates to the existence of a special relationship duty owed by defendant Ebony Parker to Miss Abigail Warner as part of a class of individuals, if we may be heard on that at this time.
All right, I mean, is there anything outside the briefs that you've already filed? Or it is?
It is, Your Honor.
All right. All right, so you have rested, or no, do you want to make that motion before you rest, I guess?
Yes.
All right. All right, go ahead.
Judge, could I say the defense would object to this argument being heard, just because I think I would rest on the prior arguments that I raised from the defense of the motion and no need to limit their theory of prosecution. There are some overlapping arguments here. I would just contend that this is not an appropriate time to attempt to revive a prior theory, alternative legal theory that this court has already heard and considered a motion for summary judgment and dismissed with prejudice.
All right, I'll hear the objection at this time.
Yes, Your Honor.
I'm sorry, the motion at this time.
Your Honor, ultimately, when a claim is pled as a duty for the special relationship was pled in this action, which was count 3, it remains before the court, and it is the province of the court to reconsider or reevaluate its rulings at any point in time before the case is dismissed. And specifically, the courts have observed in circumstances involving motions for reconsideration, if there's been a ruling as it relates to a motion for summary judgment, which is a mixed question of law and fact, in other words, facts were provided to the court at that time which may not have been wholesome or complete as it relates to what has now been preserved or presented at trial, it is appropriate to renew the motion, and then ultimately Your Honor will rule on it as Your Honor deems appropriate and fit. So the legal position here, Judge, is grounded in the court's decision, the Virginia Supreme Court's decision in Burns v. Gagnon, which was, as we've cited before, 283 Virginia 657. And specifically, it is a special relationship that was first recognized by the Virginia Supreme Court in the Burdett case. The Burdett case involved a case involving a sheriff's deputy who came across an individual on the side of the road. And the observation of the court in that case, and this is a quote from the Burns case, which is quoting the Burdett case, which says, "When a negligence claim is made against a public official, a distinction must be drawn between the official's public duty owed to the citizenry at large and the official's special duty owed to a specific identifiable person or class of persons." And then the court goes on to say in Burns, not quoting Burdett, "Only a violation of the latter will give rise to liability," quoting Burdett again, "because it is not in society's best interest to subject public officials to potential liability for every action undertaken." It goes on to say that in determining whether a special relationship exists under the present facts, that is the facts in Burns, it observed that here it is important to consider whether Burns reasonably could have foreseen that he would be expected to take affirmative action to protect, in that case, Gagnon from harm. What we have here, Your Honor, is a duty that reflects exactly that, in our view, which is that the assistant principal, based upon the documentation that's been submitted, that's Exhibit 22, Exhibit 109, the testimony of Farish and the testimony of our expert, as well as the others, who all were under the understanding of a protocol that the assistant principal had a special relationship as it relates to each of them to handle circumstances, specifically as it relates to the possession of a firearm, but certainly when there's a foreseeable risk of a firearm on campus. And under those circumstances, the court has recognized that while Ebony Parker did not owe a duty to the public or the citizenry at large, there was an identifiable class of persons at Richneck Elementary School who were under or subject to reasonably foreseeable harm, to which she did owe a duty. That is a special relationship separate and apart from the assumed duty of care that we've talked about previously. And as a result of that relationship, Your Honor, we believe that the evidence sufficiently demonstrated, A, that it existed, that is, there is a distinct special relationship between her and individuals, which Ms. Zwerner is a class member of, as a teacher, as a staff member of that school at the time, and then also that there was reasonable foreseeability in this circumstance in light of the fact that there were repeated multiple reports that reached Miss Ebony Parker, Dr. Ebony Parker, excuse me, as it relates to the firearm on campus and in the possession of JT. And I bring that point out because one of the foreseeability analysis in this case and other cases is, do we know who might have something that's dangerous? And it was Nina Farish's testimony that specifically quoted Dr. Parker in terms of her interview that identified it. A, Dr. Parker was aware of the gun. B, Dr. Parker was aware that JT was reported to have the gun. And C, through the testimony of both Nina Farish and Mr. Rawls, as late as 1:40 p.m. that afternoon, 2 hours roughly after her first notification of a firearm, there was still understanding that there was a firearm present on the campus in light of the fact that they said, let's wait and see once Mom gets here. It wasn't, we don't need to, there's no firearm. It was, let's wait and see. And so in light of those circumstances, Your Honor, we believe that it is appropriate to instruct the jury when we get to that point as it relates to a special relationship first recognized in Burdett, affirmed in Burns, and then demonstrated through the evidence today.
Thank you. The court's going to deny your motion to reconsider and relies on its opinion previously published in this case on that issue. All right. Now, having made that decision, any other motions?
Yes, there's a motion from the defense judge. Motion strike.
Well, now you're resting, right?
Yes, Judge.
Okay. Plaintiff now rests. All right. Mr. Hogan.
May it please the court.
You may proceed.
Your Honor, for convenience, I've shared some case law with opposing counsel. I'm sure he's familiar with it. If I may pass this up to the court as well. I'm sure Your Honor is very well familiar with this. We have litigated this many times, these issues, but I think it will still benefit the court. Thank you. And Your Honor, let me note as a threshold matter, there will be two components to this motion. The first, I intend to proceed on a ordinary motion to strike based on the elements and whether or not the plaintiff has established a prima facie showing necessary to survive a motion to strike. In addition, after this, my colleague, Mr. Alex Bennett, will approach the podium and make a renewed motion to dismiss based on workers' compensation. I'd ask the court to consider that as well.
I'm not
But
going to hear argument on that.
I understand,
You,
Judge.
you can renew it now. No, you need another associate to do it, but that'll be a real quick decision.
I understand, Judge.
All
Just
right.
want to make the court aware of that.
All right.
With respect to the motion to strike, Judge, the standard's well established. Even viewing the purpose of the motion to strike, it is proper to grant one where it is conclusively apparent that the plaintiff has proven no cause of action. The court has to require and accept as true all the evidence favorable to the plaintiff and grant the plaintiff any reasonable inferences that may be drawn from the evidence. This is a very favorable standard. We can view the evidence in the light most favorable to my opponent. Nevertheless, Judge, given the binding and unequivocally clear Virginia case law when it comes to the assumption of a duty in the specific context of third-party intentional or criminal harm, the steep threshold evidentiary showing that is required to trigger that obligation, combined with the steep evidentiary showing that is required to establish gross negligence, I would contend that they have failed to make a prima facie showing. To give a quick overview, in this case, plaintiff needs to establish that, number one, Dr. Parker voluntarily and expressly assumed a duty to exercise reasonable care to protect Abigail Warner from third-party criminal harm. I understand my opponent will dispute that this is criminal harm. The same doctrine under the assumed duty applies equally to intentional harm, so it is immaterial. For purposes of this hearing, I'll just reference it to as third-party harm. That's number one. Number two, they need to establish that Dr. Parker breached that duty under the relevant standard of care to a degree amounting to gross negligence. In addition, they need to establish that that gross negligence was proximate cause of the alleged injuries. And then, in addition, they need to establish the three potential prongs under the restatement second of torts, as recognized in Burns versus Gannon. And under Section 324A, there are three potential avenues for liability there. In conjunction with the elements I've just identified, they need to establish either that Dr. Parker, her gross negligence increased the risk of harm to Ms. Warner, or Dr. Parker undertook to perform a duty owed by another person to the plaintiff, or yet alternatively, number three, that Ms. Warner suffered harm because of her or a third person's reliance upon Dr. Ebony Parker's alleged undertaking. And I'll talk about reliance and emphasize it in the course of this argument, Judge, because case law has shed light on what is required to establish reliance. So focusing first, Judge, on the duty element. First and foremost, two pieces to this, Judge. It's got to be express, and then number two, there's authority establishing that a promise alone is insufficient as a matter of law. It needs to be combined with an affirmative act in furtherance of actual performance of the undertaking. Regarding the first point, Judge, the Supreme Court of Virginia has held unequivocally that an assumed duty to protect another from third-party harm cannot arise unless there is an express undertaking. An express undertaking, that means an express communication of a, quote, specifically described undertaking to take on a legal duty to exercise reasonable care to protect another from third-party harm. It has to be clear, unambiguous. It has to be talking, saying something. The case law is established that an implied undertaking is insufficient. And the case law has also established, it has defined an undertaking. In general, it is referred to, it equates to a promise or agreement. So what this means is that in the context of third-party criminal harm, in order to be on the hook for that, they need to establish that there is an express communication of a specifically described undertaking that's essentially a promise or agreement that Dr. Parker said to the plaintiff or to another person in the course of the day on January 6, 2023. A promise or agreement specifically to protect the plaintiff from the criminal harm or intentional harm that befell her. And the record is devoid of that, Judge. We've heard no testimony whatsoever that Dr. Parker made any express promise to anyone. At most, it has always been a reliance on implicit or implied tacit assurances. In fact, that was expressly pleaded in the plaintiff's complaint. In paragraphs 41 and 42 of the complaint, they alleged specifically that Dr. Parker, quote, expressly assumed a duty to protect Abby Zwerner by making certain assurances that were, in essence, assurances that JT was unarmed, and then failed to fulfill those assurances by taking additional steps to ensure that they were true. That was their allegation. But we haven't heard anything about any express promise or agreement to say, I am going to protect you, Abby Zwerner. At most, it has been implied. And there's good reason for these principles, Judge. The reason is because, in general, third-party criminal harm, those acts are unforeseeable. Generally, as a matter of law, they are unforeseeable because you cannot control the volition of other individual actors. Witnesses repeatedly acknowledging that no one would have expected a 6-year-old to bring a firearm from their home into an elementary school and shoot a teacher. This is as unforeseeable as it gets, Judge. And the rationale for why these rules exist, for the express undertaking requirement, are particularly acute in this case. It has got to be express. It cannot be left to conjecture or implication. It has got to be verbal from Dr. Parker, and that is not here in this case. There's no evidence whatsoever of that. The court has repeatedly reinforced this principle. First, it was articulated in Terry versus Irish Fleet, which the court is familiar with. There's a copy for the court's reference. But that's when they first came out, and the Supreme Court was at a fork in the road. They had to decide, look, we understand that for ordinary negligence cases, you can raise your hand and take on a legal duty that doesn't otherwise exist under the law through your conduct alone, through your voluntary conduct. And they gave examples. They cited the Nold case and the Pullman case. These are all cases dealing with a motorist who's traveling down the road. They see a pedestrian on the sidewalk. They signal over. They have no obligation under the law to signal to the pedestrian that it is safe to proceed. Yet by doing that, they have assumed a duty, or arguably have assumed a duty, to exercise this duty safely. You can't wave someone across the street without exercising reasonable care. And in Nold, they said, yes, that can happen. And whether or not that you have undertaken a duty to protect someone based on those gestures or implied conduct depends on objective reasonableness. But in Terry, the question was whether or not does that same general principle extend to the third-party harm context, third-party criminal harm, third-party intentional harm context. And there they said unequivocally, no. The Supreme Court put its foot down and drew the line there. And the reason they said that, they provided a rationale. It was not arbitrary. They said that if we did not require an express undertaking, to leave this to implication would be too ambiguous. It doesn't define the scope of the responsibility. It doesn't define how long someone undertakes this duty. It's too ill-defined for someone to be subject to liability for these unforeseeable third-party acts. And that's what's happening in this case, Judge. You've heard from their own witnesses. No one could have foreseen that the 6-year-old child would have come to school and brought this weapon and perpetrated this act. It is unprecedented. I acknowledge, Judge, that in the case law under AH versus Church of God in Christ, there is language. Church of God in Christ came in 2019 after Terry, 1 year after Terry, and it acknowledged Terry's holding, but it said, look, conduct that is tantamount to an express communication of a specifically described undertaking may be sufficient to trigger an assumed duty to protect another from third-party harm. And they cited specifically to the Nold, the case, the portion of the Terry cases cited the Nold cases. I would emphasize, Judge, that did not alter the standard. Terry is a standard. Terry has always been the law. It is the precedent, and it was unequivocal that an express undertaking was required. An express promise or agreement. Implied conduct alone is insufficient. And the Court of Appeals has repeatedly affirmed that principle, recently in Good versus Huguenot Springs. That was 2024 VA App Lexus 441. That is a 2024 case, Judge. And that one, they said, noting that under Terry, a duty to protect another person from third-party criminal harm can, quote, arise only after an express undertaking, meaning an, quote, express promise. It has to be explicit. And when they applied it to the facts of that case, it's very similar. It's informative to what happened here. In that case, there was a landowner who owned property. He allowed and authorize someone to come onto the land for recreational purposes. He did not inform that party that there are tenants that occupy the premises, and might become upset. Nevertheless, his guests went onto the property, and unbeknownst to him, the tenants came out. Of course, they became upset, and an assault occurred. He turns around and sues the landowners. He argued that by authorizing them to enter the land, he tacitly assured, without saying it, he tacitly assured that it was safe to do so. And the Court of Appeals rejected that. They said, Terry is the law. You cannot have tacit assurances when it comes to third-party criminal or intentional conduct. It has got to be express. It has got to be explicit. And that's as recent as 2024, Judge. This is binding, established precedent. Independent of that, Judge, there's another problem with the duty element, and that has to do with the fact that under Kellerman versus McDonough, which I did not provide that in the materials here, Judge, but we have, I'm sure the court is familiar with it. It appears on our briefs. In the concurrence by Justice Kinzer, he notes that how they use the term undertaking under Virginia law is somewhat ambiguous. Some hold that it's a promise or agreement. Some say that it requires an affirmative act in furtherance. Some jurisdictions apply an amalgam. Here he was emphasizing that, look, an express promise or agreement alone is insufficient. Even if someone promises another that I'm going to protect you, you cannot be liable in tort for that. And part of that has to do with the fact that in Virginia it is well established that nonfeasance, basically liability for not acting, does not impose tort liability. You cannot be on the hook for tort liability generally based on contract. Contract and tort, church and state, generally separate and independent. And that's what happens when all you have is a promise or agreement to do something and there's no follow-through or performance. Then that you're seeking to impose tort liability for what amounts to basically a contract. And in Kellerman, they noted that even though the assumed duty doctrine seeks to kind of reconcile these principles, at the end of the day, what is required to trigger tort liability, there must be an affirmative act in furtherance of the promise. And that's why in Kellerman, that was the case where there were parents who dropped off children at another parent's house, asked them, it's fine if they do a sleepover, but do not take my daughter on a trip. Do not allow my daughter to be driven by inexperienced male drivers. And they promised. In response, in that case, they replied, I promise we'll take care of her, or words to that effect. That is the language that appears in the opinion. And in addition, the mom not only promised that, but she then allowed the children to go to a mall and be transported by an inexperienced male driver, which resulted in tragedy. There was a collision. There was a combination not only of a promise or agreement, but an affirmative act in furtherance, because the mother actually assisted in transporting the children, authorizing their transport by the individual that was prohibited by the other parents. And in Kellerman, they said, look, this is the law. You need an affirmative act of furtherance, not a bare promise alone. How does that relate to this case, Judge? In our case, the plaintiffs have repeatedly asserted, and their witnesses have claimed, that Dr. Parker was indifferent. They argue that people were banging on the door saying, there's a firearm here, and she's not acting. And several witnesses have testified that she did not look up or respond at all. If that is their evidence, there cannot be an express undertaking to protect Abby Zwerner. There cannot be. The absence of action is the complete opposite of what this doctrine is all about. It's about making promises and then failing to fulfill them, or making promises, acting on them, and then ceasing your voluntary undertaking that results in harm. And we have none of those things here, Judge. At best, the critical moments, you've heard counsel in opening statement and during the evidence in this case emphasize that there are repeated reports, 4 reports. Those are the critical moments where the jury needs to consider the evidence and see what evidence was exchanged at that time. And what we've heard is that there's no one who's come into court and said Dr. Parker has responded, yes, I'm going to get right on that. Yes, I will take care of this. It is all implied. It is all left to their subjective interpretations of her demeanor. You've heard Amy Kovac testify that she went into the office and Dr. Parker didn't respond when she was talking about searching the backpack. You've heard Abigail Warner testify that when she entered the office, Dr. Parker didn't look up. That is their contention. And if that's the case, there cannot be an expressly assumed undertaking to protect another from third-party harm. Additionally, Judge, I want to focus on, under the restatements, we have these prongs. There are 3 prongs for avenues for recovery here. There's reliance, there's increasing the risk of harm, and there's also assuming a duty owned by another to the plaintiff. I'll just be very quick on this, Judge. The theory dealing with liability based on assuming a duty that another person owed Abigail Zwerner, that is not an apposite in this case. It has nothing to do and has no application here. Generally, that type of that doctrine applies where there's a company that by contract has agreed to render a service for another entity. So it's usually like a security service that by contract agrees, I'm going to carry out this business's safety obligations. We've got none of that here. It has no bearing here. The other component here is increasing the risk of harm. They would have to establish that in addition to an express undertaking, by promising to protect someone, it actually left Abigail Zwerner worse off. It exacerbated the risk of harm. And we don't have that in this case, Judge, because again, their evidence was that Dr. Parker did not act. Not acting cannot amount to an express undertaking. Not acting is their theory, and if that's their evidence, it's insufficient as a matter of law. Finally, Judge, when it comes to reliance, the restatement itself just uses the term reliance, but the case law interpreting it, AH versus Church of God in Christ, and several others, Terry versus Irish Fleet, it's actually 2 components, at least. It has to be justifiable and detrimental. Detrimental reliance requires that by promising or agreeing to protect Abigail Zwerner, it induced her to rely on that and forego taking additional safety precautions she otherwise would have done. The record is silent on that, Judge. We've heard no evidence from Abigail Zwerner, despite the opportunity to testify to this. She never testified that if Dr. Parker had done X, Y, or Z, I would have done this, and I would have exercised reasonable measures for my own safety. We have no inducement, we have no detrimental reliance. In addition, Judge, independent of the detrimental element, it has got to be justifiable. Justifiable meaning reliance fails as a matter of law if it's not reasonable. It has to be objectively reasonable. And that's where those motorist cases come in. The Nold case, the Ring versus Pole case, those are all about, look, if somebody knows the true facts, if somebody knows there's a threat and reports it up to somebody, and the administrator or executive says, look, you're safe, there's no need to be alarmed, but you have independently, through your own investigation, with your own eyes, seen there is an imminent threat. If that's what your theory is, that's what your evidence, it would be unreasonable as a matter of law to rely on that. There can be no reliance as a matter of law. This is well established in a variety of contexts in Virginia law, Judge. It's in fraud, it's in the assumed duty context, it appears in judicial estoppel. This is a well-established principle. It must be objectively reasonable. And especially where the party that's asserting reliance investigated the facts themselves and tried to identify what's going on here, what is the threat, they can't rely on somebody else. And that is what happened in the Nold case, Judge. Well, let me say this. That is what happened in the Nold case where there was a pedestrian who they could see. They were crossing the street and they looked and they could see that the driver or motorist was not in a position to determine whether or not there was a risk or not. So the risk was more foreseeable. It was equally foreseeable and accessible to the pedestrian versus the driver themselves was not in a position to see if there was a threat. And the pedestrian could see. It would be unreasonable as a matter of law to rely on somebody waving you across the street when you can see there's a truck coming down the highway. That's what it means. And so here, taking their evidence, viewed in the light most favorable to them, we dispute this, but under that standard, if they're saying, there's a fire, there's a fire, there's a fire, they're watching the fire happen, there's a train crash coming, and then they're reporting to a party who's not present, who's not on scene and witnessing this firsthand, they can't then say, oh, well, we relied on this person who wasn't present. We know the true facts, we know what's going on, but we're reporting to this person who's off scene, and I'm going to rely on what they're telling me that we're safe. That would be unreasonable as a matter of law. Finally, Judge, I just want to emphasize that independent of all of these arguments, at the end of the day, this is a gross negligence case. That is a demanding legal standard, and what it amounts to is they need to establish indifference, not inadequacy. The case law is well established that if the evidence shows that there was an exercise of at least some degree of care by Dr. Parker, this doesn't go to a jury. And this is crucial, Judge. We have heard from Amy Kovac testified, and on day 2 of trial, she, in essence, testified that Dr. Parker assented to a search of the backpack, that Dr. Parker directed her to search the backpack. She would dispute that, but in the transcript, it appears on page 199 of the day 2 trial transcript, she was asked, and so then, Ms. Kovac, did Dr. Parker respond to you or give you any direction? And she responded, she kind of nodded and acknowledged that that's what I was going to do. And Ms. Toscano asked her, you let her know that I'm going to check the backpack? And she said yes, and she nodded her head. That is a subordinate going to an administrator, telling them, I'm planning to search a backpack, and looking to them for guidance, for direction, was the question. And in response, Dr. Parker nodded her head. What does that mean? That means that is not indifference. That is not someone disregarding reported threats. That is acknowledging the threat, looking to her subordinate, who is requesting assent and authorization to search a backpack, and she's giving it. That is an exercise of at least some degree of care. And just because there was a bad outcome, or some jurors might disagree with the decision that additional steps might have been required, that demonstrates that there was an exercise of at least some degree of care. And it's not just that. There's the searching of the backpack, and there's also the directing other staff to tell Mrs. Warner, you can call the mom. You can call JT's mom. If you are uncomfortable, I'm trusting your judgment and discretion. You are someone who is on scene in a position to see whether or not this threat is imminent or not. And I'm authorizing you to act.
So if you agree that that's what the evidence is, aren't those express undertakings as well and undermining your first argument?
I would actually argue two things, Judge. I think these are we can argue in the alternative, and they can't have it both ways.
Okay. All right, go ahead.
So I think that's astute of you to pick up on that, Judge, and I think it makes sense. I think their evidence establishes the exercise of at least some degree of care, and alternatively, they fail to establish the assumption of a duty. Thank you.
Thank you. All right, I mean, you can stand up and renew your motion on the workers' comp. I'm denying it based on what I ruled on before, so if you want to put that on the record, that's fine. I'm not listening to any argument.
Your Honor, we would just place on the record our continuing objection to the court's subject matter jurisdiction to even hear this claim based on the workers' compensation bar, Virginia Code 65.2-307.
All right, court notes your renewed objection to my previous ruling that this was a personal injury and not workers' comp. All right, I don't need you to respond to that. You can rely on everything we've already said in my written opinion. Okay.
Concept.
Yeah.
To respond to the other stuff.
Yeah, absolutely.
Yes, Your Honor. Your Honor, I just observe for the record that I think the understanding of what is well established in the law in Virginia is in high dispute here. And in fact, at one point in time, opposing counsel told you that there is binding authority from the Court of Appeals from, I think it was the Good case, and I think cited another Court of Appeals case, both of which are unpublished. which means that you actually doesn't bind you. And so I think it's important for us to recognize that all of the rhetoric surrounding the argument about what is and what is not the law is not what guides this court, of course. It is what the law says it is. And when we talk about an instance such as this one, and the framing of it from the defendant's perspective, which is that this is an act of third-party crime, or the pivot that we hear today, intentional act, the law says it cannot be. It cannot be either of those things, no matter the evidence before the court, and it cannot be those things because a 6-year-old does not have the capacity for an intentional act or a criminal act. And that's been recognized in the criminal court decisions. We've cited to this in a footnote in one of our motions in limine oppositions. And in fact, it's reflected, at least implicitly, within the Virginia model jury instructions, which talk about the fact that anyone under the age of 7 doesn't even have the capacity to be negligent, let alone gather the mens rea, if we use the criminal term, to actually form any form of intent that is recognizable under the law. And it's important to distinguish that because Terry versus Irish Fleet and the progeny of cases in which they are now citing all stem from this presumption and assumption that it is an intentional crime committed by an adult. We're talking about sexual abuse crimes or crimes of criminal assaultive behavior, all from an adult, never a minor in those cases. And how we can distinguish that is in the Burns case, when it doesn't involve an adult, there is no discussion of that area of the law in regards to this express undertaking. It was before Terry versus Irish Fleet, but in terms of these criminal assaultive behavior contexts. I say that because it's indicative of the applicable law here, which we believe it allows an implied undertaking under 324A, although we don't think that our evidence requires an implied undertaking in order for this to survive a motion to strike and ultimately go to the jury for a decision, and largely for the observation that Your Honor just made right before the close of their argument, which is to say that during the course of this day, and I will hold their feet to the fire on this, if their position is that by nodding her head, Dr. Ebony Parker acknowledged a threat, such that there was a joint action taken by Ms. Kovac as her subordinate, that is an undertaking. That is an undertaking specific to a firearm on the campus at Richneck Elementary, beginning at 11:40 in the morning and ending at some point that afternoon when school's out. And why I make that point is that if relates to that implicit or implied criminal undertaking, talks about how in that circumstance, the alleged undertaking, this is a quote, is necessarily ambiguous and there is no designated beginning or end to the undertaking. That's not true here. There is a specific undertaking. There is a gun on campus. There is a specific time frame. It is 11:40 and this child's going to leave school at 2:30. That's when mom's coming. And repeatedly from that moment, the evidence has demonstrated that she acknowledged the threat, counsel's words, that they repeatedly failed to act, which is a choice, not nonfeasance, it's misfeasance. And why is it misfeasance? Because the protocols and the policies that have been admitted into evidence said that this is actually what you're supposed to do. You are supposed to do these things in this circumstance. And it is misfeasance not to comply with those protocols. It's not a nonfeasance circumstance. And ultimately, when we get to this issue of is this surviving a motion to strike, which is our narrow issue before the court at this moment, I would point the court to the footnote in the Terry versus Irish Fleet case, which observed that when the issue is not whether the law recognizes a duty, but rather when the defendant by his conduct, in this circumstance, her conduct, assumed a duty, the existence of that duty is a question for the fact finder. And even the Burns case observed that it was inappropriate to make a decision on that case involving an assumed duty of care before it was actually provided to the fact finder to then make a finding as it relates to an assumed duty and then render a verdict or a decision as it relates to that finding as well. And so on the issues of an assumed duty of care, when we look at the Burns case, which cites to 324A, we believe that all three of the prongs are applicable in this circumstance. A, her failure to exercise reasonable care increases the risk of such harm. Everyone in this school was waiting on the cavalry, and the cavalry was Dr. Parker, because that's what the protocols stapled to the back of Miss Zwerner's classroom told her would happen. And that's what she understood based on the questioning of Miss Zwerner, even in cross-examination, was going to happen. And then this argument, as Mr. Hogan points out, which is, well, there's no, it's inapplicable to talk about an undertaken duty to perform a duty by the other to the third person. My question to the court then is, why are we talking about all the things that the other teachers were supposed to do then? If you want to talk about all the things that the other teachers were supposed to do, they've practically demonstrated the assumed duty of care in that regard. And then third, the harm is suffered because of reliance of the other or the third person upon the undertaking. I point out to the court, this is where, there's a difference between how you cook your steak well or rare, and they say it's well-established law, and I'd say their arguments are rare. And the reason I say that is they're citing to cases that are inapplicable in this context as it relates to reliance. When you're talking about fraud claims, or in the context of a case involving a pedestrian on the corner of a road and whether or not to cross the roadway in the Knoll case. It's not about reliance. It's about a question of contributory negligence in the context of crossing a roadway. And the motion that's being made in this moment is not a motion that they've met their burden on contributory negligence. The motion is that we haven't put enough evidence before the court for a reasonable fact finder with all inferences in our favor, and viewing the light of the evidence in our favor, could not reasonably conclude that the issues in the case at bar fall in our favor. And so, as it relates to the duty, I think it's well established, quote from them, and I'll move to this issue of gross negligence. On the point of gross negligence, Your Honor, and just because I think that this is an issue that will obviously turn its head again if we argue jury instructions, there's a pertinent case from the Virginia Court of Appeals, which is the Howard versus Harris case that came out in 2024, where the court essentially observed that the evidence at the trial court level was actually sufficient for a gross negligence finding. And they observed sort of this circumstance in which an officer had cuffed somebody and therefore exercised some care, but that in and of itself didn't amount to this scant care requirement or scant care language within the Elliott case, which preceded or predated this. And I point that out because it has a great recitation of circumstances in which gross negligence may still be found, in circumstances if the jury were to even interpret the conduct as exercising care in the beginning. And that's a jury question of whether what Dr. Parker did was a demonstration of care in any regard. And I'd point out to the court that there's a case, Chapman versus City of Virginia Beach. It was Mr. Bright's case. He'll tell us about it later, in which the question was, and the instructions I think will be appropriate to the jury, about you can have multiple instances of simple negligence that amount together to gross negligence. And if nothing else, even our view is each act of a firearm on campus, which they claim is unforeseeable, and yet their handbook says weapons on the property, meaning they're foreseeing a weapon on the property. Each instance in which it wasn't addressed and gotten to the bottom of by Dr. Parker is evidence of gross negligence and indifference. But as Dr. Shufflebarger testified to, our expert, ultimately, in culmination, it is absolutely shocking. It's absolutely shocking, the facts of this case. And she used those words, which are words that are parroted by the Supreme Court and the courts as it relates to instructions, whether the conduct shocks the conscience, but is somewhat less than reckless indifference, which is sort of how the courts quote that language. And so, for the reasons stated, Your Honor, I think we've demonstrated sufficiently at this stage for a jury to determine the finding of the assumed duty of care, the assumed duty is recognized under the law as Your Honors previously articulated, and that the evidence before the court is sufficient to demonstrate that there's gross negligence.
Thank you. All right, the issues that have been raised are issues for the fact finder, which in this case is the jury, to decide. At this time, the court finds that there is sufficient and credible evidence that the defendant assumed a duty of care, breached that care in a grossly negligent manner, and that breach was the proximate cause of the plaintiff's harm. That will be all for the jury to decide. I deny the motion to strike. All right. Yep. All right. Having said that, you said you have one witness ready, or did you need to check it?
Let me check to see if they're present. They should be here. It would be Deputy Thomas Blythe. Let me check.
He's here.
He's here. All right.
Already checked.
We're in the jury.
Your Honor, before you do that, I have a motion with regard to Bly.
Oh, that's right. Okay, I apologize. You did warn me. All right.